We live in 5, 4, 3, 2, 1.
Oh yay, oh yay, oh yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning, counsel.
Good morning, Your Honor.
Good morning.
Appreciate y'all being here with us by Zoom. We don't anticipate any problems technology-wise, but if we should have any, everybody just take a deep breath and we'll pause while the experts fix it. I used to say while we fix it, but everybody knew that was not exactly an accurate statement. Mr. Hivner, call the case, please.
Jonathan Finley versus Wettermark Keith.
We'll hear from the appellant.
Hello. I would like to thank the court for taking the time to hear this case, and I hope that you will rule in my favor with the remand to the lower court with supervision. I'm going to go ahead and get into it. The defense argues that there's no disputes about the material facts and that it is somehow supported by a statement of undisputed facts. The plaintiff, however, argues that there are disputes about relevant facts of this case. The plaintiff would like to state the facts in his own words. On August 24th, 2018, the plaintiff was in an accident. The accident caused an injury to the plaintiff, and the plaintiff sought an attorney to assist. The plaintiff then found Wettermark Keith. Upon finding the firm, the plaintiff signed an employment contract with the defendant in which Wettermark Keith was to represent him in all claims revolving around the accident that occurred on August 24th, 2018. Now, after a whole fiasco in 7 months, the defendant only came away with a settlement of $2,800 from Tia Holland. Furthermore, the plaintiff was left with the impression that the defendant would sue General Motors for injuries sustained by an airbag in the form of second-degree burns to the arm. The defendant states that they send a letter stating that they can no longer represent the plaintiff. However, the plaintiff does not remember receiving said letter, and there's no proof that the letter was sent or received, or that the letter even existed. The plaintiff's statute of limitations ran out, and the plaintiff filed suit in Hamilton County Circuit Court, where the defendant stated that there was a statement of undisputed facts that supported their claim to dismiss. The plaintiff disputed those material facts. However, the court did not agree, and the circuit court ruled that 5 months was enough time to find a new attorney, holding that the defendant's evidence was enough to show that there was that 5 months time was enough to find a new attorney, and deemed inadmissible several pieces of evidence to show the defendant's guilt. The plaintiff filed a timely appeal requesting that the case be heard by the appellate court to disallow the letter evidence and to allow the case to be reheard in lower court with supervision so that the plaintiff will be allowed to enter evidence. The plaintiff knows that he cannot enter evidence in the appellate court because of rules surrounding the preparation of records, which is the reason that he's asking for this case to be remanded to the lower courts, hopefully with supervision, and he will be able to enter evidence to prove his case. In the original case, this is the errors. The court made several errors in favor of the defense. The main error revolved around evidence and entry of evidence. The plaintiff submitted an offer of evidence, which included contract, medical records, police reports, settlement offer from Tia Holland, company filings from General Motors, and several other pieces of evidence. These pieces of evidence were deemed inadmissible, and the Tennessee Rules of Evidence 401 talks about relevance. It defines relevant evidence. Rule 401 states that evidence that has the tendency to make the existence of any fact that is consequence to the determination of an action more probable or less probable than it would be without the evidence would make it relevant evidence. Rule 402 states that all relevant evidence is admissible except as provided by the Constitution. The relevance of evidence to the case makes it admissible. Almost all of the evidence that the plaintiff entered was relevant evidence. Medical records show that the second-degree burns sustained by an airbag. Police reports indicate there was an accident. Settlement offer indicates that the defendant was representing the plaintiff, and the amount that the defendant supposedly recovered. The company filings indicate there was potential knowledge that there were issues with the airbag. and other pieces of evidence show that the airbags are not supposed to be harmful to the user, and only supposed to be supplemental seatbelts. Most of all, the contract indicates that all parties responsible for injuries are to be sued by the defendant. In talking about evidence, the defense will argue that the letter evidence that they claim to have sent is relevant. However, there's no evidence that it has been sent or received, and the plaintiff does not remember receiving said letters from the defense, even though they say it was sent. This will make it an arbitrary piece of evidence. The plaintiff refers to Taylor versus Stanley Works. In this case, the court ruled the certified letter was not enough to show proof of service. And though this is not a service, this particular letter contained relevant information that was needed in order to proceed to make decisions. It would be equivalent to the seriousness of the service. Furthermore, it's not relevant because the defense failed to meet standards of attorney with dealing with clients, which means that the evidence should not change the outcome of the case. Attorneys are supposed to be prompt in dealing with clients. The defendant was not prompt in dealing with the plaintiff. Because of this, the letter evidence should not be allowed. It is irrelevant. And also the communication was never shown to be made to the correct person or actually made. The defense is going to try to use the argument that 5 months is enough time to motion to dismiss the case based on the letter. However, there are several reasons that this case should not be dismissed, even if the letter evidence is allowed. The first reason that the case should not be dismissed is that the defendant is a professional attorney. This means that under the rules of professional conduct, they are to act competently, promptly, and diligently. If the defendant were acting promptly, it would not take 7 months to receive an alleged communication about the case. The alleged communication would happen probably within 3 months, reasonable time. If the defendant were acting diligently, they would have filed suit against General Motors in accordance with contract and lawful instruction. If the defendant were acting competently, the settlement that was offered to the plaintiff would have been more than $2,800. The second reason that this should not be dismissed is the fact that the lower court never offered the plaintiff the chance to fairly try the defendant. The plaintiff had several pieces of evidence that were thrown out. He tried the motion for evidentiary hearing that was declined. He issued an offer of evidence, most of which was deemed inadmissible. There were just a litany of things that made this case almost impossible to try.
Counsel, I'm sorry, let me interrupt you before your time runs out. Did your client, did the defendant file a statement of undisputed material facts?
They did file a statement of undisputed material facts. And
Did your client reply to that statement?
Yes, sir. I replied to the statement, and I'm the plaintiff. I'm the plaintiff.
Yes, sir. I'm sorry. Yes, go ahead, Mr. Finley. It was a long weekend for me, I guess. But did you reply specifically to those to the statement of undisputed material facts?
Yes, there was specifically replied to the statement of undisputed material facts.
All right.
It was a disputation of material facts, or disputation of undisputed material facts. It was a disputation. The third and final reason that the case should not be dismissed is that a fair trial with evidence entered gives everyone a chance at a fair and equitable outcome. It would give the defense a fair chance to show that there's actually insufficient evidence to prove that there's a claim against them, as opposed to just railroading the plaintiff to come to an outcome. I'm sure the defense would appreciate this, giving them the chance to clear their name and remove any undeserved criticisms. And to dismiss this case currently as presented would be a gross miscarriage of justice, because the totality of circumstances surrounding the case would not have been considered. And we all know that when we don't consider the totality of circumstances, we create situations where there are unjust outcomes. And I'm going to go into a little bit of a tangent here, because, I'm talking about justice, and I just feel like true justice has been fleeting in Hamilton County. And the reason that I say that is because of previous experiences that I have had with the Hamilton County court system. I feel like judges may have not been interested in hearing certain cases, or that could be because I'm not an attorney, could be because my cases are inartfully pleaded, or it could be because they're just not interested. But I mean, no, there's Haynes versus Kerner, and which means that a plaintiff or a pro se plaintiff is not necessarily held to the same standards as a professional attorney, but it could be for several reasons. But I just feel like this is symptomatic of what's going on in Hamilton County. And like I've learned, and though I've learned a lot about the system or about Hamilton County court system, I just see this as me having to like file this myself as like a first sign that there's an issue within the Hamilton County system. And the plaintiff can point to several other cases that he feels that there's a problem with, or there has been problems with the judicial system. I can bring up the case of Tennessee versus Brandon Steinberg, and I know this is a tangent, and the case of Jonathan Finley versus Brandon Steinberg. And those are just cases that I've personally witnessed where it just didn't work out for the plaintiff, because I don't know whether it's because the plaintiff is African American or because I'm African American or whatnot, but it just hasn't worked out. And there's been evidence to actually like proceed on these particular cases.
Mr.
So,
Finley, you've used your time, Mr. Finley. You still have your time for rebuttal.
okay.
We'll hear from the appellee.
Good morning, Your Honor. Thank you. My name is Donald Vowell, the Knox County Bar. I'd greatly appreciate the opportunity to be here on Zoom today. That's helpful to everyone. So thank you for making that available. Of course, we're here on summary judgment, the beginning point here today, I think, is that Mr. Finley did not submit any evidence, no affidavits, no admissions, no interrogatory responses, really nothing, no evidence at all. The only facts in the record are the listed here in the statement of undisputed facts that the defendants filed, the law firm of Wettermark and Keith. And there were 10 of those, and Mr. Finley did indeed respond to the statement of undisputed facts, and he disputed one of them. He only disputed one fact. So the facts that we have in the record, Mr. Finley had one visit to the clinic, and he had a bill of $95. He instructed counsel to accept an offer of, it was $1,800. He agreed to that. And then when the check came, there was a release with it, of course. And so he refused to sign the release because he thought it would prejudice the rights of his unborn children. Then we get to the key facts in the case, and this is number 8 in the statement of undisputed facts. Mr. Hassinger, who was the attorney for Wettermark Keith, informed Mr. Finley by telephone and by letter that they would not be further representing him. In his phone call, he said, I explained that I could no longer help him in regard to any case. Then in the letter, it said, we must decline any further representation of you in your case. We will not be filing a lawsuit on your behalf. It's imperative that you immediately seek out the advice of another lawyer and timely file a lawsuit if you wish to pursue your case. Now that was 5 months before the apparent statute of limitation would have run. It's plenty of time for Mr. Finley to do whatever he needed to do. The letter went on to, alert him, you need to take action if you want to pursue your case. One of the background documents for the facts is the request for admission. item number 4 of the request for admission was admit that you, on the date, March 22nd, 2019, you spoke to attorney William H. Hassinger by telephone, and he told you that Wettermark Keith would no longer represent you. Well, Mr. Finley admitted that. He said in his response, I did speak with attorney William Hassinger and was told because you didn't sign the release, there was nothing else I can do for you. And he also confirmed in his own, his own document, I would not sign the release. I balled up the release. I don't have children, but I did it because I don't want to hold anything against my unborn children. So those are the facts of the case. Mr. Finley says he doesn't remember receiving the letter, and there's no proof that the letter was sent. Well, of course, that's incorrect. Mr. Hassinger's affidavit says it was sent, and Mr. Finley did not dispute that. So I think that fact is taken as given in the case. Mr. Finley says that he submitted an offer of evidence, but it was deemed inadmissible. Well, there is nothing like that in the record. There is a document that he filed after the judgment was entered where he lists some things, but there's no, these things, if they ever were offered into evidence, it's not in the record. And there's certainly no order deeming anything inadmissible. There's only 2 orders in the case. The one, the parties initially did not file the Rule 56.03 Statement of Uncontested Facts. The court put down an order giving them 7 days to do that. And then, of course, there's the order of granting the summary judgment. So, the facts that Mr. Finley states in this evidence that he says that he somehow submitted, but it's not in the record, it has to do with getting burns, second-degree burn on his arm, and the fact that he contends that airbags are not safe. Well, that, of course, even if it was in the record, it has nothing to do with the dismissal of the case. The case did not fail for lack of damage. It failed because the law firm withdrew. They and advised, not withdrew, it wasn't, there was no lawsuit filed, but they withdrew from any further representation and clearly told him, both in writing and by letter, that they were not going to file any lawsuit for him. So the other thing that Mr. Finley complained about this morning was he said that the defendant was not prompt. Well, I don't know, even if that, I don't know how he could say that, because he had, they got him the best offer available.
Mr. Val, let me interrupt you a second. Mr. Hivner, do we still have Mr. Finley online? Or Nick?
It appears that he's coming back on with us. So.
All right, let's pause it a second then until he gets back on. You back with us, Mr. Finley?
Yes, sorry.
Okay.
Sorry.
We lost you for a minute, but we had Mr. Val pause while we got you back on.
All right.
Okay, go ahead, Mr. Val.
So I think that was pretty prompt, even if that promptness was somehow an issue. I'll mention a couple of things that Mr. Finley said in his brief that he did not mention this morning. He said that he was not allowed to object to any statement that the defense made, inferred, or entered into the record. Well, of course, they can object to anything that he wants to, but there's nothing, no order, no ruling, nothing in the record to support that. Then he says there was several fabrications that were entered into the record by the defense that the plaintiff wanted to object. Well, no way of knowing what those fabrications supposedly were. And of course, he could object to anything that he wanted to. Then he says he requested subpoenas that were not granted by the court, which were related to the case, and also was not given the chance to depose any witnesses. Well, of course, the court does not grant subpoenas. A party can request any subpoenas that he wants to. There's, nothing in the record about that. As far as not being allowed to depose witnesses, he can depose any witness that he wants to 30 days after the filing of the complaint. But he didn't. And then he says that the court was not interested in finding out the facts of the case. Well, of course, it's not the court's job to find out the evidence. It's up to the parties to submit the evidence. And as I mentioned, Mr. Finley didn't submit any evidence. He says that he ordered Wettermark Keith to file a suit against General Motors for the second-degree burns. Even if you could order attorneys to do things like that, there's no such fact or evidence in the record. So he then reiterates this idea that there's no proof that the letter was real or was received. Well, the affidavit clearly says that it was. There's a copy of the letter, and Mr. Finley did not dispute that in his statement of, or his, as he called it, the disputation of evidence. He only disputed item number 2. He didn't dispute anything else. And then finally, he says that there were several errors in favor of the defense by way of favoritism. And I think he was alluding to this in his oral argument today. There's, again, no way of knowing what these supposed errors were. There's nothing like that in the record, and certainly no indication of evidence or even reason to believe there was any favoritism. So I think that probably concludes my comments on the case. I think that the trial court was very correct in dismissing the case because there were no disputed facts. The law firm capably represented Mr. Finley got an offer of $1,800 where you had a $95 in damages plus a second-degree burn. Got that within, I believe it was within 7 months, and Mr. Finley agreed to it, then changed his mind and wouldn't sign the release. And so the law firm then disengaged the way you should do it. They did it exactly the way it should be done, leaving their client with plenty of time to take other action. So thank you for your attention this morning, Your Honors.
Thank you. Mr. Finley, you have your time for rebuttal.
Yes. All right. Thank you. Now, as I'm disputing these facts right in front of you today, the defense is saying that there's no disputation of the facts as I dispute them. It's I don't know what to say about it. It's just I'm disputing the facts. Also, the defense talks about the 5-month period. 5 months. If we take a year, they say I have 5 months, but they had 7 months to actually file the suit and let me know about what should happen in regards to my case. So they were not being prompt because 7 months is the greater part of a year. If this would have been a 3-month time period, they would have definitely given me enough time. The majority of a year is greater than 51% of the cause of the problem. So that argument that the defense makes is I think is not a valid argument. the defense also states that in their response that I filed subpoenas that were denied. I issued an offer of evidence they said it was after after time was available, but there was several attempts to enter evidence into this case that were not allowed. And because that was not allowed, that's an error on the court's part, because I should be able to file evidence. So, what I'm asking is for the appellate court to remand this back to the lower court so that I can actually enter evidence in this case that was intended to be entered, that was attempted to be entered, and that was basically just railroaded out through the whole entire proceeding.
Is that all, Mr. Finley?
Sir.
You may be aware of the process we follow, Mr. Finley, but just to make sure, we'll take the case under advisement, then we'll issue a written decision, an opinion on it, and we'll send it to Mr. Val and to you at the same time.
Sure.
All right. Thanks to Mr. Val and Mr. Finley both. And Mr. Finley, again, I apologize for forgetting that you were the plaintiff, which probably says you were doing as good a job as a lot of lawyers we see. So that's probably why I was misled. All right, again, thanks to both sides. Mr. Hibner, if you'll recess court until our next scheduled case.
Thank you, Your Honor.
This honorable court is now in recess until 10:30 a.m.